The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Scott Makar, Judge, presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Well, good morning, everyone, and thank you for having us here in Clay County Courthouse. We're very pleased to be here. We're also very pleased to have many guests in the courthouse. We've got the Clay High contingent over here and the Clay County Court over there. So the game plan for this morning is we have two cases. Each will take approximately 40 minutes each, and then once those are concluded, we'll open it up to the students for Q&A. You'll get to meet some of the local trial judges as well. With me today, and at the outset, let me say this. Typically, in a typical appellate court situation, we have 3 judges. We're all on the same level, on the same bench. But because it's so tight up here, there was a decision made to kind of separate the judges out. It doesn't mean because I'm elevated a little bit higher, I'm any more important. I'm just happy to be presiding today. We have Judge Stout here, who's from Jacksonville. I'm from Jacksonville. We have Judge Boatwright from the Black, just up down the street. So the lawyers, we will, for the appellants, we'll have you reserve some rebuttal time. And we have 2 cases, so we'll get right into it. The first case is 24-2323, Roe versus NPC International. Ready to proceed?
Yes, sir.
Would you like some rebuttal?
5 minutes, please.
Very good.
Good morning. May it please the court. My name is Dimmitri Pettas, and I represent the appellant, Jacob Roe. This case is about a statute of limitations. A statute of limitations sets a deadline to commence an action. And this court has held that as long as an action is timely commenced before the deadline expires, what happens later is irrelevant. But here, the trial court treated a statute of limitations not just as a deadline to commence an action, but also as a deadline to finish an action. Specifically, plaintiff voluntarily dismissed his claim against NPC's employee after the statute of limitations expired, and the trial court ruled that this exonerated NPC.
Did the plaintiff even need to name the employee in the lawsuit?
No.
Is that a requirement?
No.
In order to sue NPC, then you don't need to sue, the employee didn't need to be named in the lawsuit.
Correct. This court has held that, and it's undisputed. The parties agree on that point. And that's an option that the plaintiff has. In a situation like this, where you have someone who commits a tort, and then an employer who's vicariously liable, you can sue the employee, the employer, or both. And here...
Did I hear you say the parties agree on that principle?
That's correct, Your Honor, and I can actually cite that for you. Let's see. So, for example, in the answer brief, it's page 32, and NPC says, VA, that's referring to this court's case, the VA case, stands for plaintiff's ability to elect who an action will proceed against. We also have amicus briefs in this case, and the amicus brief in support of NPC also recognizes, on page 3 of that brief, the law in Florida is, and always has been, that a plaintiff may choose who to sue, the employer, employee, or both. And here, we sued both, and we sued them timely. The statute of limitations gave us 4 years. We sued within 1 year. And so it's undisputed that we timely sued them.
So if this is a plane crash, the pilots were negligent, and the plane went down, the pilots died. Would their estates have to be sued, or the employees are no longer living?
Right.
So what would happen in that situation?
I think that kind of identifies the problem with the trial court's ruling here. It really creates a mandatory joinder rule where the plaintiff is forced to sue everyone for whom the employer is vicariously liable. And in a case like this where it's a crash and you just have one employee and one employer, it's pretty simple. But there's all kinds of cases where this could be really complicated. Imagine a construction project or medical lawsuit where you have multiple employees who might have been negligent, and you don't even know who they are. Under the trial court's reasoning, you would have to sue each one of those employees, or else, like here, after the statute of limitations expired, the employer would claim they're exonerated. And there's no case that
So how do you distinguish that from the Tsuji case, if I'm pronouncing that right, on the Florida Supreme Court? What you're saying?
So there's 3 reasons why the Tsuji case is distinguishable. The first is that in Tsuji, the plaintiff did not timely sue the defendants. The statute set a 2-year deadline, and it's undisputed the plaintiff did not meet that 2-year deadline. So that's already one big distinction between that case and this case. Here it's undisputed we timely sued the defendants. The second distinction is that in Tsuji, we were dealing with the court was dealing with a different statute.
And is the term liability in that statute important?
Correct, it's very important. It's a probate statute. They called it a statute of non-claim. And what it says is that the decedent's estate, the personal representative, or the beneficiaries, they shall not be liable. And the court really focused on that plain language. Here, we don't have anything like that.
The trial court in that case actually made a decision that the decedent was not liable, correct, in the decedent's estate.
That's correct.
Did that happen here in this case?
No, and that is exactly my third distinction, is that there was an adjudication in Tsuji. And what that means is that the trial court, as you said, Your Honor, actually ruled on that issue. Here, that never happened. Instead of an adjudication, what happened is that a party, my client, Mr. Rowe, voluntarily dismissed without prejudice his claim against NPC's employee. And this is important because what the court said in Tsuji is that this exoneration rule really depends on an adjudication on the merits. And we see that same phrase in the Florida Rules of Civil Procedure. It's Rule 1.420, and subsection 8.1 of that rule recognizes is that when you have a voluntary dismissal, like this case, and it's your first voluntary dismissal, you haven't done it before, it's not considered an adjudication on the merits. And so we have not only precedent telling us that this isn't an adjudication on the merits, we also have a rule using the same exact phrase. We've also cited some other cases that arose in the proposal for settlement context that have recognized that even in a situation like this, where you have a voluntary dismissal after the statute of limitations expires, it's not an adjudication on the merits. And one of those cases, the Harrell case, recognized that if you were to hold otherwise, you'd be contradicting Rule 1.420. You'd be denying the plaintiff their option to voluntarily dismiss an action. But not only do we have case law saying that a voluntary dismissal without prejudice, like here, is not an adjudication on the merits, we even have a case from the Florida Supreme Court that says a voluntary dismissal with prejudice is not an adjudication on the merits. That's the JFK Medical Center v. Price case. So, for those reasons, the trial court erred.
Were those cases dealing with settlements?
The cases I was mentioning before, the Harrell case, yes, was dealing with, in JFK Medical Center v. Price, there was a settlement.
Does that matter?
I don't think it matters, Your Honor. MPC tries to distinguish Price based on that. But if you read the opinion, what the Florida Supreme Court was concerned about is that if you were to hold otherwise, you'd be encouraging litigation. And in general, the courts want to discourage litigation. And as I mentioned earlier, if you were to treat the voluntary dismissal in this case as an adjudication on the merits, you'd be encouraging litigation. Now, as an appellate lawyer, I have to advise trial lawyers, they need to sue everyone. They need to sue every possible employee, and they can't dismiss them from the case, or else the defendant, like here, will claim they were exonerated. So the same reasoning applies with or without a settlement. We're trying to prevent unnecessary litigation.
Now, if we ruled in your favor, reversed it, would we be creating conflict with any other districts?
No, Judge. The parties have not identified any conflicting decision.
So the only way the case would get to the Supreme Court would be if we certified a question.
I believe so, that's right.
Is this first impression?
So the NPC claims it is. I agree there's not a case on all fours, but maybe there's cases on, you can take 2 and 2, there's the principles from case law, you can build them together to decide this.
Sure, but the effect of Suji's decision on this case is first impression.
Right.
I'm not aware of any case, we've not been presented any case as to the effect of Suji from the Supreme Court, its applicability when a defendant has been dismissed for whatever reason, voluntarily dismissed.
Right.
There's no answer, no court has spoken to that question.
That's right, Judge. And I think that's why it would be helpful for this court to write an opinion explaining, why Suji is distinguishable, help trial judges who are facing these issues.
So help me frame the state of affairs. If, and I emphasize if, the court determines Suji governs,
Mhm.
does the appellee prevail? Does it dictate appellee prevails?
So I guess it depends what you mean by Suji governs. I agree that Suji, of course, is binding precedent, but I don't think it controls the facts in this case.
If we were to determine it applies to the facts of this case, does it dictate appellee prevails? Don't worry, I'm going to be asking your colleague the same question in reverse.
Yeah, I think you would still have to contend with JFK Medical Center v. Price, which is a Florida Supreme Court decision. And there's a principle of appellate law that the Florida Supreme Court does not overrule itself silently, isolation. Right, and the Florida Supreme Court did not say in Suji that it was overruling Price. It acknowledged Price, citing it in a footnote, but this court can't presume that Price was overruled. So that's still a Florida Supreme Court precedent that applies to this case. There were some other decisions that the court cited. The trial court cited Mallory O'Neill. It's an old Florida Supreme Court case from the 50s. Mallory doesn't really address the facts here. It doesn't address the requirements for the exoneration rule. It just stated the general principle, so it really doesn't have any application here. The trial court also cited the Buettner v. Cellular One case from the first DCA, and that case is distinguishable for 2 reasons. First is that, like in Suji, in Buettner, the complaint was untimely when it was filed. And again, here, we timely filed our complaint. And then also in Buettner, there was an adjudication on the merits. The trial court granted summary judgment based on that statute. Here, there was no adjudication.
The exoneration doctrine applies only when there's an adjudication on the merits.
Correct, that's what the Florida Supreme Court
Your
said.
position is for this court to determine there has been an adjudication on the merits in this case would run contrary to the text of Rule 1.420.
That's right.
And the reason for the voluntary dismissal, whether settlement, whether the day before trial, whatever, the contemplation, strategy, or otherwise, irrelevant because the rule would suggest it cannot be considered with prejudice under the rule or an adjudication on the merits. Both phrases being used under 1428.
Right.
Okay?
Is there a situation where a voluntary dismissal could be considered an adjudication on the merits under the rule?
I can't think of one, Judge. I'm not aware of one. I haven't seen a case where that happened.
Does Rule 1.420 contemplate that if there's been a prior dismissal without prejudice,
Oh, that's correct.
and then there's another dismissal voluntary, that can be considered?
The rule does say that expressly. So, for example, you
That did
can't.
not happen in this case.
No, that did
That's what
not.
I was getting.
Yeah. So you can't just go around voluntarily dismissing and refiling suit. The rule stops the plaintiff from doing that. So you only get to do it once, and there's no claim that this was, there's no evidence that we had done this more than once.
Well, it seems to me there's 2 types of exoneration. There's one where there's actually factually an exoneration. The employee not doing anything wrong. No negligence. Actually proven. Exonerated. And then there's the legal fiction. That if you dismiss after 2 times, it's an adjudication on the merits. It doesn't really exonerate in the sense that there was a factual determination, there was no negligence. It's just by fiat. We've determined that's going to be an adjudication on the merits. So there's at least the 2 types of exoneration going on.
Yeah, and it seems a little strange, because like you said, the exoneration rule is a common law rule. And it started, the quintessential example is where you have a jury trial. And you go to trial and the jury finds the employee not liable, but somehow finds the employer liable. And the courts created this rule because that just doesn't make sense. The employer is only vicariously liable, so how can you find the employee not liable, but the employer liable? So that's the original situation that the exoneration rule was created for. And really what's happening is that NPC is trying to expand the exoneration rule, put a square peg into a round hole, and it really just doesn't fit. This isn't a situation that the exoneration rule applies to. I would like to just address a couple more cases. There's, below, NPC relied on the Walsingham case from the first DCA. Again, it's distinguishable. That was a voluntary dismissal with prejudice. Also, it was decided before Price, so Price obviously controls over that. And in fact, courts have recognized that the continued viability of Walsingham is in doubt. NPC also relied on the Alley case from the Florida Supreme Court, and that's distinguishable because it involved an adjudication by the trial court. The trial court dismissed the claim, and so that's an involuntary dismissal under Rule 1.420B. And then finally, the NPC cited the Carnival case, and that also involved an involuntary dismissal. So all those cases are distinguishable. We'd ask this court to reverse, explain that Susie is distinguishable, the trial court erred in relying on it, and this case should go back to the trial court. Thank you.
Thank you, Counsel.
Good morning, and may it please the court. Teresa Savona on behalf of the appellee, MPC International. I'm going to start where my colleague started, and that essentially was discussing this court's opinion in law with the election of actions. Now, I want to note that we do agree, to your point, Judge Sal, and as my colleague indicated, the parties agree, election of actions, we don't dispute that. And again, that means a plaintiff can sue an employee, an employer, or both. So let's talk about what an election of actions means.
But they do not need to sue the employee if they do not choose, correct?
Correct, Your Honor. Now, the election of actions comes with advantages, disadvantages, and consequences. Va versus Garner is an example of an advantage of a plaintiff only suing an employer. Because if an employer is only sued and the employee is never sued, which was the case in Va, then the employee there can never be an adjudication on the merits. The exoneration rule will never be triggered. It will never come into play. That is different than the case here. This case demonstrates the disadvantage and the consequence of a plaintiff's election of actions of suing both the employee and the employer, And the reason is, in this case, the employee is the active tortfeasor.
So if you're claiming vicarious liability, though, you're saying that if you don't have to bring the employee into the suit, you still have to prove the employee caused some type of harm. You just don't have to name them in the suit.
For purposes of the election of actions, yes, and that's what VA was about.
Wait, is there a lot? I'm sorry, Judge Brewer, go ahead.
No, go ahead, just say.
Is there a logical inconsistency with that position? In other words, a plaintiff, the captain has a growing complaint, can choose to sue an employee or not, and sue the employer. But if you sue the employee and then subsequently voluntarily dismiss under 1.420, that then the exoneration doctrine would apply, and there can be no action to proceed against the employer.
The exoneration rule applies. The dismissal comes after the statute of limitations. That's, I think, the biggest thing. Now, I know my colleague said this case is about the statute of limitations. That is part of the story. This isn't that the claim was untimely brought. I think we both agree on some very fundamental procedural facts.
What if they dismissed with prejudice? before the statute of limitations runs?
There's a dismissal with
Of the
prejudice.
employee.
There's a
How
dismissal.
is that any different than the statute of limitations running down the dismissal?
Well, because essentially they are kin, they are tantamount.
So in that example, they did dismiss before the statute of limitations had run, dismissed with prejudice.
Yes.
Well, maybe settle them, I don't know. But they dismissed them with prejudice. You still have the same position, which is there's been an exoneration, employer is not liable.
I want, if I can clarify, Judge Maycar, you said if there's a dismissal with prejudice or settlement, and I want to be very, very clear. If there is a settlement, and I'm not arguing against the case law that says if the active tortfeasor is sued and the plaintiff settles with that active tortfeasor and the passive tortfeasor is also in, so a both situation. If there's a settlement with the active tortfeasor, that settlement is not an adjudication on the merits, and so the exoneration rule is not triggered.
But, so your position is, however, a strategic decision to dismiss the employee the day before jury selection begins is different than materially different than a settlement constituting an adjudication on the merits extending the exoneration rule.
Only if it is after the statute of limitations.
But to Judge Maycar's point, what if it's the day before the statute of limitations runs, they decide to let the employee out, and then afterwards the statute runs? Your position is that cannot extend the exoneration doctrine then?
Well, we're not talking about the exoneration doctrine. I want to be very clear. I'm distinguishing what VA is, which is different because the plaintiff in that case only sued the employer. And this goes to a point that my colleague is making, saying that my client's position is a mandatory joinder rule. That is incorrect. We are not advocating for a mandatory joinder rule.
But he's arguing that's the effect. You're not arguing for it, but that's the effect.
And I would disagree with that, Judge Maycar, for the reason that federal case law has indicated that a dismissal without prejudice after the running of the statute of limitations is tantamount to a dismissal with prejudice and therefore an adjudication on the merits for that dismissed employee, because the plaintiff cannot refile. And that, Judge Stout, is why the indication of the statute of limitations running is so important. Whether it's the day before trial, I think as former trial judges, you saw defendants being dropped right before trial. The strategy decision comes when the statute of limitations has passed, because it begs the question, what can a plaintiff do on a time-barred claim? And the case law...
When you say that, what's your authority for that statement?
For
when the statute of limitations passes, everything after that is an adjudication on the merits. What's your legal authority?
Yes, Your Honor, there is as I indicated, this is the federal cases.
Florida without. But I mean, Rule 1.420 says it's not, unless you previously dismissed without prejudice and do it again, then it's an adjudication. That's authority.
Understood, Your Honor. 1.420 is silent on the implication of the statute of limitations. I acknowledge that there is what it defines as dismissal without prejudice, and when that can be an adjudication on the merits, that was just discussed with my colleague. I acknowledge the involuntary dismissal of the Part B of that rule. I'm not challenging what the rule indicates, because it is silent on this issue. And I think to go to Judge Sow's question, is this an issue of first impression? It is based on the facts of this case. I agree with my colleague that this is really looking at the law as it stands in Florida and applying it to the very specific fact situation of this case. But what I do want to indicate is the federal case law that I am referencing, which is Stevenson versus Warden from the 11th Circuit Court of Appeals and Burden versus Yates versus from the 5th Circuit Court of Appeals. And those indicate that there is nothing left when you come to what can a plaintiff do. A plaintiff cannot refile on a time-barred claim. And that is where we get to SUGI. The rationale from SUGI. This isn't saying that everything is on all fours. I think both parties agree there is not a single case in Florida that is on all fours. But this isn't an elections of actions issue. This turns on the sheer application of Respondeat superior and the exoneration rule in an instance like this, where the plaintiff makes the strategic decision to sue both employee-employer, makes the decision or for whatever reason cannot settle with that active tortfeasor, because we know there's case law that says there's different about that, and then dismisses the active tortfeasor after the statute of limitations is run, because there's nothing left that can be done. Now, if the plaintiff in this case had not sued Ms. Ward, the active tortfeasor, the one who was driving the car and hit Mr. Rowe, let's change the facts. Plaintiff did not sue Ms. Ford, then this case is dictated by law. And that says that the plaintiff can only sue NPC at that point because it is the election of actions. It is our position that actually furthers preserves a plaintiff's choice in electing who to sue.
If the court determines, and again I emphasize that, if this court determines that the principles you rely upon from SUGI are not applicable in this case, does that dictate the appellant prevails?
No, because the Florida Supreme Court has long held the exoneration rule outside of SUGI. So we have bankers, multi-law.
Did not your brief rely substantially on SUGI? I mean, in the trial court, as I read the transcript, it was entirely SUGI. The trial judge, who's a very good trial judge, was told SUGI governs this matter. And he may not have used the word governs, but that's how I understand it was presented on the record. Am I wrong?
I'm not disagreeing with you.
And then your briefing seems to rely primarily on SUGI.
My briefing does include SUGI. It does rely on SUGI because that was what was discussed below. But I also want to be very clear that it started with the doctrine of Respondeat superior and the long-standing case law from the Florida Supreme Court, from Bankers Multi-Line Insurance versus Farish and Williams versus Hine from the Florida Supreme Court in 1920. So our answer brief actually started with the bedrock exoneration rule and Respondeat superior, saying this is where we're going to start. And then let's go.
Do you concede that the exoneration rule applies only when there's an adjudication on it?
Yes.
So then it is determinative in this case, could be determinative in this case, whether or not the voluntary dismissal the day before jury selection after the expiration of the statute constitutes an adjudication on the merits.
It's our position that that type of dismissal is tantamount to a dismissal with prejudice because there's nothing left to be done.
Did the trial court actually ever make that determination about that this is an adjudication on the merits?
There was no finding, but Your Honor, there was no finding by that. And I think that's why we're looking at the federal courts where that issue was addressed because we don't have case law from a Florida court.
Well, perhaps did the trial judge not make that determination because everything presented to him was centered on SUGI?
Possibly, but that's also where the tipsy coachman doctrine comes into play, Your Honor, where the appellate court can affirm for reasons that maybe the judge got to the right result, but did so in the wrong way. So I acknowledge that SUGI was heavily relied upon, and it does appear in the record.
Was your argument presented to the trial court? Outside of SUGI, your arguments as to the exoneration rule, common law being applied to this case, the federal precedent that says this is an adjudication on the merits because the voluntary dismissal came after the statute. Was that presented to the trial judge?
This was in response to the initial brief that was filed by my colleague.
Okay. Was it presented to the trial judge?
I don't believe to the extent that wasn't the answer.
Is that a preservation issue?
I don't believe so because this court, as the appellee, this court can affirm under tipsy coachman.
Okay.
So I think the preservation argument for purposes would be more on the flip side for the appellant, where this court couldn't deal with an issue that wasn't properly presented the first time. So what we have here is if this court disagrees with SUGI or disagrees its application of SUGI, you can still affirm for NPC on the basis of the Respondeat superior and the exoneration rule, because SUGI is used, and if you look at the trial court's order, that indicates that the rationale of SUGI, it's not saying SUGI is on all fours. It's saying that the rationale and the application of that can be used here, and that goes to the point that my colleague and I are both making, which is you have to look at these bedrock principles, and our positions are just fundamentally different with how those results are.
And I want to be careful because it's not for us to disagree with SUGI. SUGI is the Florida Supreme Court. We're bound by it. The question is whether or not SUGI applies to the facts of this case.
Correct.
And you can see the facts are materially different here than in SUGI.
To the extent that they are not on all fours, I will concede that SUGI deals with a statute of repose, but where I will not concede, Your Honor, is SUGI dealt with an election of action where a plaintiff sued an active tortfeasor and a passive tortfeasor. And because that active tortfeasor's claim was barred by a statute of repose and ultimately untimely, that was an adjudication on the merits. So you have an untimely barred claim. Then the Florida Supreme Court correctly found and applied exoneration rule, Respondeat superior rule, by saying, well, because that acts as an adjudication on merits for the active employee tortfeasor, well, then there's nothing left to impute, and that goes to the Banker multiple lines, the Williams versus Hines, the cases that we do rely on. So Suji is founded on these principles. So Suji, I do not concede that Suji is 100% different. The facts are different. I acknowledge this is not a statute of repose case.
Is that material? The fact that that's a statute of repose, that was a statute of repose within the probate code in Suji, and here we have a statute of limitations. Is that material?
I think, is it material to say, I'll take a step back. Those aren't the facts of this case. Is it material? I don't believe so, because we have now a time-barred claim. So it's not saying that the statute of repose, and I want to be very clear, I'm not saying the statute of repose and the statute of limitations are the same thing.
Yeah, they're very different.
That's correct. So I'm not making that position. And neither did the trial court. The trial court indicated that the rationale in Suji could be used. And so that's what we're saying. But
Well, it could be used if we had that statute.
sure, so we can take
That was a
Suji.
statute that said there's no liability.
Correct.
The statute of the other statutes, they don't say anything about liability, right? Statutes of limitations, they just say you can't bring the claim. They don't say that there's no liability.
Correct, Your Honor. And that's why even if this court says we're not comfortable saying Suji is the way to go, affirmance can still occur because Suji applied it to the statute of repose, and understanding that that is not the same, understanding that statute is not at play in this case, that even if you take that out, you take Suji out of the
But
equation,
how do you get around the fact that they timely filed? In this case, they timely filed.
because it's not about when they filed in this case. And that's where I want to be clear. I know that there was discussion in my colleague's reply brief saying this case is a timely filed
But
case.
Suji was all about filing after the.
Well, correct, Your Honor.
This
And-
is not that case. Different universe.
Well, Your Honor, I'm not disagreeing with you on that very fine point, because that goes to why there isn't a case on all fours. So we're not saying Suji is on all fours. We're saying that the rationale applied for a barred claim, an untimely claim. So we take a step back, an untimely claim acts as an adjudication on the merits. It is our position that when you dismiss voluntarily on your own the active employee tort after the running of the statute of limitations, that acts as, that is now a time-barred claim. They can't refile,
Unless it's dismissed for settlement.
but it wasn't.
But
And I agree with you.
But if it were,
I agree if it was
is that
dismissed.
another logical inconsistency?
I don't believe so, because a settlement is a negotiated contract between the parties. The parties can come up with what they want to say. So we're not saying that settlement is different. This isn't a JFK Medical Center versus Price case because there was no settlement. And that also doesn't say how this court could ignore the Respondeat superior exoneration rule that's long been held by the Florida Supreme Court for over 100 years. So it's not that there's an inconsistency.
Well, there's no factual exoneration, right? There was an adjudication that the employee was not named.
Correct, there was no jury.
So you have to point to some legal authority that says that there has been an adjudication on the merits. And the statute in the Supreme Court case had no liability, so that was determined to be adjudication. What do you point to here? What is your legal authority in this case to say that the trial judge is correct?
The legal authority in this case are the two federal cases that I've cited, where it talks about when you have a dismissal without prejudice after the running of the statute of limitation, that prevents a plaintiff from refiling the claim, and that is tantamount to a dismissal with
And that was
prejudice.
under Florida law in both cases.
No, Your Honor. So that, I had,
What law was it under? Is it Alabama law or?
well, one is the Fifth Circuit, so I don't.
Texas, okay.
So, but this case, the exoneration rule, when we talk about what it is tantamount to, our position has always been that Suji.
So you're saying we have to adopt some other jurisdiction's law to get to your position?
No, Your Honor, that's not my point. My point is that this court can affirm based on Respondeat superior exoneration rules, because even if you look at the Alley versus Ionata case, there are cases that say an adjudication, a dismissal without prejudice based on time-barred claim can be an adjudication on the merits for res judicata purposes. So this isn't that our position is a far-fetched idea. Again, these are positions that I think both sides have very deeply briefed because we don't have a case exactly on point, and we're taking what we believe are the legal.
You know, res judicata, the matter's already been resolved. Sure. The plaintiff is just trying to have his or her day in court.
Sure.
For the first time. So that distinction?
and I'm not saying that that is 100%, but when we're talking about all the different positions, the main cases that we have cited are Florida Supreme Court cases. This isn't VOG because there was 2 individuals sued, not 1. I think relying on these responding superior principles, that in and of itself leads to it. So understanding that Tsuji is not 100% factually on point, this court can turn to that rationale. And what's interesting is Tsuji, in reaching it towards the end of the opinion, just as Curiel discussed the Buchner versus First Cellular case from the first DCA. Now that also was a timely barred claim, but that was under a statute of limitations case. So understanding that was looking at a different statute, and I believe Buchner also involved the same probate statute, but it was applying statute of limitations principles in a statute of proposed analysis for drawing parallels. So again, we're not saying that these are identical statutes. We're not saying they should be treated the same in every single case, but this case presents itself in a very unique situation where if a plaintiff dismisses the active tortfeasor after the statute of limitations run, there's nothing left that can be done. And Mr. Rowe, in briefing and even below in response to the motion for summary judgment, has indicated and acknowledged that the trial court has no jurisdiction.
When you say nothing can be done, but if they had just sued the employer, nothing can be done?
I'm saying...
I don't understand that. Well,
Sure, you are, and let me back up, and I do apologize.
Look at Tom.
I say I still have some time. Nothing can be done in the facts of this case. When you have an employee and employer both sued, you have the employee that is dismissed without prejudice after the running of the statute of limitations. That claim is time barred. So when my reference to nothing can be done, it's because there's nothing left to be done on that case. Again, correct. And so if you can never find that person is liable, you can never impute anything because there's nothing left to impute because the plaintiff sued both. That is why this case is not dictated by law. And I see I'm running out of time.
We'll take 30 seconds or so and wrap it up.
Thank you, Your Honor. Basic Respondeat superior principles support the dismissal of the vicarious claim against MPC. A plaintiff who elects to sue both the employee and the employer, but does not settle with the employee, cannot circumvent the statute of limitations or the exoneration rule by dismissing the employee after the statute expires. For these reasons and those previously set forth in our answer brief, as well as the amicus brief by the Florida Defense Lawyers Association, we respectfully request this court affirm the trial court's order granting summary judgment in favor of MPC.
Thank you, counsel. If we could add 30 seconds.
Thank you.
If you need it.
Thanks, Judge. Opposing counsel mentioned this concept about circumventing the statute. And you'll see that same concern in Susie. The court was concerned about circumventing the statute, and so is the trial court here. They used that language in the order. We did not circumvent the statute. We complied with the statute by timely filing suit. Judge Sada, I'd like to read from the record in response to your question about what the trial court was told. And this is on page 1919 of the record. And this is what NPC's lawyer told the trial judge. All of the underlying cases referenced by Susie in support of their decision are not the case we are relying on in this case. Susie is the controlling authority in this case. So that's why the trial judge was misled in this case. They thought Susie was controlling, and as we discussed, there are a lot of distinctions with Susie. And another question was whether Susie relied on the statute. It did. I'll quote footnote 11 of the decision, where the court said, "This case does not turn on our view of the better policy, but turns solely on our statutory interpretation." That's because the statute there was what the court called a jurisdictional statute of non-claim. I quote, "self-executing absolute immunity to claims filed for the first time more than 2 years after the death of the decedent." We don't have that here. We just have the statute of limitations, which again, we comply with. There is a logical inconsistency with NPC's argument because NPC is really relying on the fact that the statute of limitations expired. But the same thing would be true if we had never sued the employee to begin with. the statute of limitations would later expire and we wouldn't be able to sue the employee.
So does it matter at all?
No, so it doesn't matter, exactly right. The federal case law that was discussed does not deal with the exoneration rule, does not deal with adjudication on the merits. Those cases were cases where the trial court, as a sanction, had dismissed the plaintiff's claim. I don't remember the exact facts, but I believe the plaintiff maybe didn't comply with some orders or some kind of scheduling deadline. So the court dismissed the claim with prejudice. And the appellate courts were saying, well, that's a very severe sanction because as a practical matter, they won't be able to sue again. They weren't analyzing whether it was an adjudication on the merits. And then finally, if this court reverses, it does not need to certify a question. You can let the issue percolate. If another DCA later disagrees with this court, that would be a conflict that could give the Florida Supreme Court jurisdiction. So this court should reverse, explain that Susie is distinguishable, and help trial courts understand the decision and understand that it doesn't apply to the facts in this case. Unless there are any questions, I'll rest.